Welcome to How Employment Cases Actually Settle, Psychology, Anchoring, and Strategic Negotiation. I'm Lorena Vasquez, Vice Chair of the Beverly Hills Bar Employment Law Section. I'm delighted to introduce our speakers today, MyKhanh Shelton and Stacie Hausner. MyKhanh Shelton is a full-time employment mediator with over 25 years of experience as a litigator, in-house employment lawyer, and senior executive at Fortune 500 companies. She began her career at Quinn Emanuel before spending over a decade at Fox, mediating and litigating hundreds of disputes in film, television, and sports industries. She later served as Senior Vice President of Diversity, Equity, and Inclusion, both at 20th Century Fox and Warner Media. My apologies, we have some type of emergency alert. Her mediation practice draws on deep knowledge of federal and state employment law, evaluative and reality testing techniques, and a focus on resolving matters that involve both legal complexity and sensitive interpersonal dynamics. And we also have Stacie Hausner, who has mediated thousands of cases across a wide range of practice areas, including employment, business, civil rights, sexual assault, and entertainment law. She has been mediating full-time at ADR Services since 2016, and prior to that, mediated regularly for California state and federal courts and various agencies, including DFEH, DCBA, and CCR. She has received the Excellence in Employment Mediation Award from the Southern California Mediation Association and has been inducted as a Distinguished Fellow of the International Academy of Mediators and is a member of the National Academy of Distinguished Neutrals. This is going to be an exciting show. I can't wait. And now let's get started.
All right. Well, thank you for that very kind introduction. MyKhanh and I are very excited to be here. Thank you for inviting us to present a program about smart moves we can make as employment lawyers and strategies we can use to optimize the outcome for our clients. MyKhanh and I have been mediating employment cases for about 13 years now, and MyKhanh as well has been mediating for a while. And given our experience with employment mediations, we want to discuss what actually moves employment matters to settlement. What changes the trajectory of a negotiation, what builds momentum, and what ultimately gets your disputes resolved. So this program is discussing what actually works in the mediation room, what stalls progress, and what unintentionally derails settlement in employment mediations. Our goal is to distill those lessons into concrete, usable strategies that you can implement immediately, whether you're early in your employment law practice or you've tried cases for decades. Of course, none of these strategies will substitute for good preparation. MyKhanh and I both feel that, the better the preparation, the better you can do in a mediation. Please know that a successful mediation actually starts long before your session starts. Know your case, know your evidence, know your client's goals, not just your strengths, but also your vulnerabilities. We could spend an entire hour really on preparation alone, but today we're going to assume you've done the prep work, and we're going to focus this on execution, the strategic and tactical decisions that can materially influence your settlement outcomes in employment mediations once the mediation begins. And so we're going to start with MyKhanh. She's going to talk about the move that shapes everything that follows, the opening move. So I'll turn it over to MyKhanh.
All right. Thank you, Stacie. Hello, BHBA audience. When it comes to opening moves, you've probably been in this spot before. On the defense side, you might be asking yourself, should we ask for an opening number before mediation so we can decide if it's even worth going to mediation? And on the plaintiff side, you might be asking, when should we make our opening demand? Should we make it pre-mediation or should we hold it for the session? And if you've already made a pre-mediation demand, you might be asking, do we stick with that number once we're in the room? What are the implications if we do adjust the number downwards or upwards? Those are all really practical questions, but underneath them is a strategic one. And it's a question of what do you want that first number to do? Because whether it comes before the mediation or in the room, that opening move tends to have an outsized impact on how the rest of the negotiation goes. It shapes expectations, it influences the range, and it frames what starts to feel reasonable. That's the anchoring effect. It's a cognitive bias where people rely really heavily on the first number they hear, even if that number is completely arbitrary. And this cognitive bias has been really well studied everywhere from criminal sentencing to real estate prices. And let me give you an example that I love and lawyers particularly love because it involves judges. In one study, judges were asked to sentence a shoplifter. Before proposing a sentence, the judges rolled a loaded dice that landed on the number 3 or the number 9. The judges who rolled a 9 proposed an average sentence of 8 months, and those who rolled a 3 proposed an average sentence of 5 months. So obviously, the dice were irrelevant. The judges knew that, and still the number they rolled pulled the outcome toward it. That's anchoring, and no one is immune. We see the same dynamic in employment cases all the time. That first number, whether it comes in a demand letter or at mediation, has a way of shaping the range. It frames expectations and it influences what starts to feel reasonable. So that's the real big advantage of going first and being able to set an anchor. But there's a flip side. An opening number that's extreme and unsupported can actually cost you that advantage, lose you that advantage. Instead of setting the frame, you might trigger a reaction. And there's a study where higher suggested tip amounts, like when you go to coffee and you see the tip boxes, there was a study that involved tip amounts, and it showed that where the higher suggested tips were like 25 to 35%, that increased the number of people who tipped nothing at all. Some people were just put off by what felt like an aggressive ask, and they opted out entirely. We see that same type of reaction in employment mediations. If your opening demand is so extreme that it feels disconnected from reality, people might opt out entirely. Actually, we usually see 3 different types of reactions. One, you might get a response in kind. So you open really high. The other side comes back insultingly low. And that's why people often refer to this first round as the insult round. Another thing we see happen very often is, so on the plaintiff side, you make a demand that is seen as extremely high and untethered. The other side will ask us, the mediator, to go get a real number, go get a serious number. And that never works because no one wants to go bid against themselves. A third response that we see very often is that people disengage. Physically, you might see people packing up their bags, threatening to walk out, but equally detrimental is the mental disengagement when people actually shut down. So now instead of focusing on resolution, the other side is spending the next hour debating whether the opening move was reasonable, whether you're negotiating in good faith, and if it's worth putting real money on the table. And sometimes that happens even earlier. If an extreme demand is made before mediation, the other side may decide it's not worth going to mediation yet at all. Or they may think they need more discovery or that the case isn't ready to be mediated. Now, that may or may not be true, but you don't want the opening number to be the thing that's driving that decision. Because at that point, you're not using the anchor to move the negotiation forward, you're just dealing with a reaction to it. So an anchor works best when it's both ambitious and defensible, high enough to influence the range, but grounded enough that the other side can engage with it. That's a delicate balance, and this is where working with a mediator can be useful. We can think through not just the number, but what it's going to do, what message it sends, what response it's likely to get, and whether that response actually moves you towards your client's goals. Sometimes you might expect a reaction. You might be telling us, you know what? We know we're going to get an insult number back, and that's okay. That's part of our strategy because we know opening numbers aren't always just about dollars. They're often communicating a message, right? Sometimes you want to be saying, my client is really upset. We want your attention. That's fair enough. But if the goal is resolution, the opening move has to invite engagement, not retaliation. So I often get asked, what should my opening demand be? How should I set it? And there are lots of different approaches. Some people think in terms of multiples of their target. Others build it from damages, lost wages, emotional distress, attorney's fees. And those frameworks can be really useful for valuation, and they should factor into the analysis, but they don't answer the strategic question. That's because the opening number isn't just about where you want to end up, it's about what you want to happen next. So, some other questions to ask would be, how is the other side going to react to it? Will it be productive to move the negotiation forward, or will it stall it out? And that's where I see cases either gain or lose momentum. So when you're thinking about what your opening move should be, it's useful to ask, what do I need this number to do? Do I want to anchor high and create room to move? Do I need to signal seriousness? Do I want to invite an early, meaningful counter? Once you start thinking about it that way and kind of opening up the types of questions that you're asking, you'll see that the number becomes a strategic tool, not just a calculation. All right, so the same is true when you're on the receiving end, okay? Assume the other side has gone first, the plaintiff side has made their opening demand and they are trying to anchor you. What do you do to counteract the anchor effect? Okay, so on the defense side, you're trying to counter the anchor effect. What do you do? First, recognize the move, okay? Don't get upset about it. I see oftentimes people tend to get very upset about how, outrageous or extreme they think that opening move is. I'm going to say, don't get upset. Recognize the move. As we've just discussed, it's probably strategic and not personal. Don't react emotionally. You've prepared, you know your range, you know what you're trying to achieve, and you've often, and I see this a lot, and it's so helpful, you've also talked to your client about it. And so you've normalized with your client that this might happen. Okay. Preparing your clients for those opening rounds is so helpful. Stacie will speak to this in a minute. Just as important as opening numbers are, we don't want anyone to over fixate on them. Okay, so she'll speak to that in her section. Okay, so how else might you counter the anchor effect? You might address the anchor directly and name it. Okay, if you simply move off their number without naming it, you risk signaling that their number is inside the bargaining zone. Okay, and if you don't want to do that, then say you don't want to do that. You can say that number is not within a range we can work with, or we're not negotiating against that number, or our aim in the negotiation is to get them anchored on this other number. Okay, that resets the frame. Don't let that go implicitly adopted. Third, you want to counter quickly and intentionally. Anchors gain strength with time. So respond deliberately and explain your reasoning. So for example, in employment discrimination cases, just as it is productive for the plaintiff to justify their opening number, for example, with a breakdown of economic damages, lost wages, front pay projections, and so on, when you respond on the defense side, it's helpful to articulate the justification and assumptions behind the number. When you're not just trading numbers, but you're actually trading analysis, that changes the tone of the negotiation. Okay, there are a couple more dynamics that I think really matter here. So keep in mind the midpoint dynamic. In many negotiations, the final number tracks somewhere near the midpoint between the first reasonable offer and counteroffer, which means, again, there's a real advantage to making your opening move defensible and a real disadvantage to starting so high that the other side won't engage with it at all. Okay. Also keep in mind that adjusting away from an anchor takes a lot of cognitive effort. It requires discipline, focus, and intentional thinking. When people are mentally depleted, overloaded with information, which may happen, particularly for clients who are new to mediation, or if they're tired, or all those things will cause people to stay closer to the anchor. And that's where a mediator can help. We can help you reset the frame, test the justification behind the numbers, and strategize moves in a way that's productive. Okay. All right. So once the opening move set the tone. The next phase, the back and forth, the sequencing of concessions, is what we call the negotiation dance. Stacie's going to take it from here and break down how that dance actually unfolds in real mediations. Stacie, over to you.
All right. Thank you for that, MyKhanh. Okay. So we're going to now talk about this negotiation dance. What happens after we have this anchor and made their initial move? And I just want to add in employment mediations in the last 13 years that I've been doing them, I've seen a real trend of plaintiffs making bigger opening moves than they used to make, which is upsetting defense. So they're going lower than they used to go. So we're going to talk about a little bit of that as we talk about these concession and the dynamics. Okay, so after the initial moves, people start moving toward one another. I call these concessions. They're making these compromises until they get to their bottom line deal. Some people call it last, best, and final. Some people call it my stop point. Some people do it in 20 moves. I think that we can do it a lot less than 20. Some do it in 3 moves, some do it in 5 moves, but essentially we're starting to move toward one another. Now, when I train mediators and I teach mediation at Pepperdine Law School, I call this the negotiation dance. And I call it a dance because your dance partners are negotiating partners with the other side. So it's a little different than litigation, right? Where they're your opponent. You are working together. So if you move right, they move right. If you make a big move, they tend to make a big move. Now, they may not think a big move is what you think is a big move, but they tend to reciprocate. There are social science studies about reciprocity, and people tend to repay favors or generous behavior with the same. And that's what we tend to see in a mediation. So if you're going to insult and go small, the other side's going to insult and go small as well. And people say to me, Stacie, I am irate. The other side's not moving. And I'll go in the other room and I'll say, look, can we get some money on the table? The other side is having a problem moving because they think you're too low or too high, depending what side they're on. And they'll say, that's not my problem. It actually is. It's all of our problem because we're trying to get to a settlement. We're trying to see if your settlement evaluations are close enough that us mediators can bridge this gap. It's great when you guys overlap. It doesn't happen that often in employment mediations. There tends to be a stopgap that we are trying to bridge. And so we are all working together to get different floors and ceilings and get us into a range of settlement. Because when we get into, we call it a ZOPA, zone of potential agreement, cases tend to settle. Now, right at the outset of the mediation, I tell people, look, everything that happens until I tell you this is the best deal that we can get here is negotiation strategy. So if somebody's starting really high and somebody going low and somebody making a little move or a big move, all of this is strategy to try to get the outcome they want. Now, I tell plaintiffs this partially because they're hearing such gigantic numbers at the outset that in comparison to it, and MyKhanh explained the very strong impact of the anchor, your clients are not immune to it. They don't see this as a good settlement. So if you're starting at 5 million because you want to settle at 700,000, 700,000 doesn't look so great at the end if you've started at 5 million. So I want to try to prevent this entrenchment and this type of thinking right at the outset. I recommend lawyers do the same. If you're planning on using high anchors and making little concession moves or whatnot, let's get your clients on board that this is a strategy. So I think you guys need to talk about it with your clients as well, so they're not so frustrated. If defense comes in and offers the plaintiff, the other day they were offered $2,500 when the plaintiff started at $875. The case settled for $250, and the defense wanted to come in at $2,500. And I said, please don't do it. It's like beyond the insult number. And they didn't listen. So then I spent the next hour trying to convince plaintiff to stay in the mediation. It did work and we did settle, but we got to be careful because if it's so insulting, again, and as MyKhanh talked, it can derail it. And same with each move. If you want to give me $1,000, in general, I think like in these employment, let's try at least 5K increments, even if it means less moves. Less than that tends to have a very insulting effect. Why does it matter? Because of the concept of likability. This guy, Robert Cialdini, wrote a book on how we can influence people without them even knowing. It's called The Science of Influence. And one thing that was very clear from all the studies and all the studies that have happened since, people give more to people they like or respect. So if you're insulting your negotiating partner, your dance partner, it's less likely at the end of the day they're going to give you what you're asking for. So let's try to make small moves if we're looking for that without insulting. And same with the anchor, like MyKhanh discussed. Okay, so plaintiffs are starting high, defendants are starting low. Everyone's trying to create space. Everyone's trying to forecast either a higher or a lower number. This can be very frustrating. And more, the trend is I'm seeing a lot of frustration and spending a lot of time trying to normalize it. Look, don't worry about it, and trying to normalize some of the behaviors. So what can we do, given this is the main frustration, when you're engaging in the dance and you don't like what the other side's doing? You don't think they're doing enough. But before I give you this tip, keep in mind a few things. One, concessions are communications. So the other side, if you start at 2 million and you go to 1.98 and then to 1.96, you are sending a very different message than if you start at 2 million and you move 200,000 and then you drop to 1.6 and move another 200,000, okay? Now, the 198, 196, you are messaging a higher endpoint, but you may be discouraging the other side that it can settle if the settlement value is, six-figure settlement value. So keep in mind that this concession is sending a message and it's giving the other side whether they are optimistic they can settle. When they're not optimistic it will settle, we got a couple problems. One, they won't put money on the table. So I have a lot of trouble getting them to get their money on the table to see if it's something you're looking for. And two, they get concerned with putting information out there. So people are protective of information because information gives them power. And if they think there's no hope of settlement, they don't want to share that special document or that video or that internal memo. They're nervous to do so. So keep that in mind when you're trying to play it really tight, that you could be actually hurting yourself in the long run. Also be aware that if you are matching each time on either side, you are messaging the midpoint. You are holding the midpoint true. So if the midpoint's great and it's higher than for plaintiffs, if that midpoint's higher than you'd actually take, which is what typically happens, then that's fine. Hold the midpoint. Same with the defense. If you really like this midpoint, hold it. But be aware that you are communicating this message should you do so. The same is true that if you were holding the same concession pattern. So yesterday in my employment mediation, defense went 10 to 20 to 30 to 40, and plaintiff was I think they started like 800, was dropping in 50K increments at the same time. So it was a 1 to 5 pattern. So then defense could read, if we keep putting 10 Zs up, where are we going to end at the end? This can be a very smart strategy. We mediators can also help you with messaging if you don't want to be so, you don't want to give it away with your patterning. We can help you with that. And we often are reading some of these messages in both rooms as you get involved in this negotiating pattern. You can also use the size of your concession to send a message. So if you're doing 50K drops like yesterday in my mediation, and that was a disability discrimination meeting, and he was doing 50K drops, then he slowed to 30, and then he slowed to 10. You're messaging to the other side, you're running out of room. So that is a pretty typical thing I see as people start to slow down to try to give that message. Keep that in mind. So if you want to have a stop point That's low. You may want to start slowing down to try to move it lower. So you can do a lot with these types of concession patterns. Okay, so now when we really don't like the move the other side's doing, they're too low. We don't like it. What can we do strategy wise? You can barely move yourself. Okay, and most lawyers like that strategy. The concern with it is quickly we get in a negative reciprocal pattern of negotiating. So defense doesn't like it. They give me 5,000. I try not to get less than 5. Plaintiff doesn't like that. So when they were going to drop 100, now they're going to drop 20,000 because they want to tell you they don't like that. And now defense is really mad. So now to get 5,000, I'm having trouble. And now plaintiff's going to respond. And guess what? This is not good. Everybody's insulted. No, we haven't triggered the likability that has the biggest impact of all. And everybody is in this negative pattern of negotiation. The benefit of it is you're telling them I'm not settling in your range. You're way out of whack. The negative is you could create an obstacle to settlement just from strategy that doesn't need to be there and doesn't allow us to explore settlement. So we end up spending a lot of time getting you out of this pattern, okay? And there's a lot of tools we have to do so, which we're going to get to in a second. The other thing you could do is do a generous move. We know this rule of reciprocity, generosity, your dance partners, if you move generously, they tend to do the same because now they have space to move. So if you've just given 100K, the other side's now, seeing you've got some movement, they actually have some room to move. This also is beneficial in that you are creating this likability concept. They're not feeling insulted. They think you're here to settle. They're going to share their information. They're going to work productively. So try a generous move. If the other side doesn't reciprocate, then give them a bad move on your next one and show them you didn't like that. Typically, I think generous moves, we can sell it as such and start getting you guys moving toward one another in a productive way. Another thing we can do is brackets. Now, some lawyers out there, and I'm sure even in this Zoom, you hear brackets and you say, oh, I hate brackets. I personally love brackets, but I leave it up to the attorneys on whether they want to use it. Why do I love them? Because it's a simultaneous jump to productive negotiating behavior without creating a floor and ceiling for future negotiations. So if you guys are floundering around at these insult moves and we do a bracket, everybody has now started doing something productive. So there's 2 ways we can use bracket. One is I can propose a bracket. So let's say defense is at 15,000, plaintiffs at 700,000. I could propose a bracket of 2 to 400,000, let's say, or 1 to 400,000. Okay, now here's the problem. 99% of the time, you do not jump into a mediator proposed bracket. Why? Because you're reading the midpoint. And defense wants to not get to the midpoint or at least message lower than the midpoint. And plaintiff wants higher than the midpoint or at least to message higher. So it is very rare that a mediator proposed bracket actually works. Once in a while, it's very exciting. It's great because now you guys are actually in the zone that can settle and settlement will quickly follow. Because once you guys get in the zone of reasonable settlement amounts, people tend to settle. They don't let the deal go. What is more typical is you get into a bracket counter bracket negotiation. And these can be very effective because these end up being bigger moves. What I caution you for when you're using it is it's a midpoint game. So if you $15,000 defendant give me a bracket of 50 to 100, you have now messaged you'll get to 75,000. That is a big jump from your 15 before, but it's just like a range jump. It's not an actual ceiling or floor type of jump. Now plaintiff sees that and they're like, oh, okay, they're close to 6 figures now. I'll give 4 to 600,000 and I'll give a 500 midpoint. That's wishful thinking. They probably wouldn't drop that low, but 5 to 700,000 with a 600 midpoint. Now we're in the game. Now everybody's saying, hey, we may be able to settle this. This is why brackets are great. Now, we can do so much off of brackets as mediators. We can move you to the hard numbers as the midpoint numbers as your hard numbers. We can settle at the midpoints of the midpoints. We can use hypotheticals and start talking and getting you into the range. There's so much to do. If you are in a 4-hour mediation, the other day I had 4 hours with joint employers. So I'm in the defense rooms. And then the plan, I got to get you moving. We can't fuddle around at the 5, 10, 15 jumps. We got to get like to it a lot quicker. In 4-hour mediations, be mindful. You got to make bigger moves or jump into brackets or something, or we're going to run out of time in those mediations. And I typically have another one after. So I'm always watching time. I don't want that to become an obstacle to settlement. So help your mediators if you've got these 4-hour mediations to do something productive with that. Okay, one of the tools we can use when you are scared to put money out, this is what I did the other day. So defendant had gotten out 30,000, but plaintiff had only come down to about 750, 700,000. And defendant was saying to me, this cannot have a 3 in it. So I hear he's looking for a 1 or a 2 in it and would probably be willing to go to 200, in the 200s. But he's now, he's 50,000. He's not near this number, but he doesn't want to put any more because he's not getting any value for his money. So one thing we can do is you can make a small move and give your mediator a sense of where you want to go. And then we can do what ifs. So we go in the plaintiff's room and say, look, he can't get out more money, or look, he's looking to create, I think he's showing you where he's looking to end. What if I could stretch him? What if I could get a 1 in it? And they may say, Stacie, no way. I don't know if I could ever get more than that, but what if I could get a 2 in it? Would you ever take that? Well, we want a 3 in it. And behind the scenes, all of a sudden, I can get this whole thing settled without anybody taking any more money out of their pocket. So with these kind of behind the scenes conversations, I can do it. It is very important that the mediators be protective of your number, not tell the other one where you're going, which we do naturally for you. You could ask your mediator, make sure, and say, mediator, how are you going to say it? I always do that. I'm like, okay, this is what I'm going to say. Are you okay with this? But this behind the scenes type of dynamic allows you to keep your money in your pocket while we explore, can I get this settled? And a lot of time when you guys are doing unproductive bargaining, this is the most effective strategy that we're going to use. So rely on us mediators. We do this every day to help you in these types of dynamics. I know MyKhanh does this type of stuff as well. Okay, another tool we can use when we're not having productive moves is keep your money in your pocket. Plaintiff, don't keep moving your ceiling, and let us give a mediator's proposal. This is typically an end of the day strategy when nobody wants to move anymore, when you guys are at an impasse. This is, most of you on this Zoom, I know this. This is when we give you a number, not what we're telling you is going to happen at trial. This is not like a trial evaluation. This is telling you what number may work if everybody stretches outside their comfort zone just from having these conversations, okay? This is very helpful because it allows you to maintain your negotiation position. So if you're at 50,000 and I make my mediator's proposal, I'm making these numbers up for 150,000, you can say yes to me, and if they say no, you're still at your 50,000. So it works that if you both say yes, you have a deal. If one of you says no, the other side never knows. So nobody is compromising their negotiating positions. So for future, 95% of cases settle. So at some point, it's probably likely you are going to settle, and you don't want to you're not creating a new ceiling or floor for yourself. We can do this in 2 ways. One, I can go into each room and deliver a mediator's proposal. You can talk it out with your client and tell me yes or no. The other way I can do it is I can put it in writing. And then I can leave it open for X amount of days. You should always have your mediator put a time component on it because that people that makes people make decisions. Otherwise, people keep it open indefinitely. And we need the scarcity of time. This is another one of these science of persuasion concepts to actually get some action on the mediator's proposal. Why would we do it? I think today is the best day to settle, always. Because if I send you away, somebody's case is going to get stronger than the other, or at least in their perception, or both sides think their case got stronger. Defense is spending more money, so they want to pay less than they were willing to pay before. And plaintiff is spending more money, even on contingency. They've got additional costs and time, and they're going to want a higher settlement value. So today's our best day. So I always want to do everything we can to get it settled that day. Why put it in writing? Because sometimes decision makers aren't in the room. I want decision makers in the room. It makes it much, much easier to settle, but sometimes you guys don't do that. Sometimes the adjuster is on the phone or getting a lawyer's take, funneling the information. Sometimes I've got a board that needs to get eyeballs on it, or it needs to get another line of authority, obviously, if we have an insurance company involved. So sometimes we need extra time. Sometimes we need a depot, or we need the client interviews. Today, defense, it was pre-lit, and it was a racial discrimination case. And they were hearing for the first time that feces, the guy wrote the plaintiff's name in feces on the bathroom wall and told him he couldn't use the bathroom because it wasn't a colored person bathroom. And defense is hearing this for the very first time today. So they're like, whoa. We gotta interview everybody. We gotta see what's going on here. So we have things like that. So
Hey,
sometimes,
Stacie.
yeah, jump in.
Okay, I think this might be a good spot for these two questions that we have in the Q&A. I've been looking, and I think this might fit into a little bit of what you're talking about. Not the anecdote you just shared, but just kind of the some of the themes. One is, can I read them out to you, and then we
Yes,
can discuss?
please, and
Okay.
feel free to jump in and answer as well.
I just think this is thematically along the lines of what you're talking about. So Juan Carrillo asks, along the lines of anchoring, does new information, i.e., info that genuinely causes you to reevaluate your settlement, lead to re-anchoring? I imagine I would tell opposing counsel, my old numbers are moot, time for a do-over, or is the cat out of the bag, and anchoring just happens once. So I think further to what you were saying, new information is new information and a time to step back and reevaluate, and you're not stuck with your old numbers. If there's meaningful change, if there's material change, what do you think?
Yeah, I think that would derail your mediation. So look, it's not just you trying to go back in the mediation. When people are genuinely trying to settle a case and they've thrown out numbers before they get to the mediation, the other side does not want to hear a number outside what has already been given. So in a mediation, if you say, hold on, I'm going backwards. I just saw a video. Like today, there was a video of one of the reported incidents. So I'm going up now. Yeah, I think your mediation's over. I think you should call the mediation, do some more discovery, and then strategize for a second session. I have never had a backward step. I think it would be very difficult to settle. You could stop and say,
Hmm.
this is it. I don't have any more room, but a backward step, I think, ends the mediation. I've
Yeah.
never seen it happen where something revealed has created somebody going backwards. Have you seen that?
Not in session, but like over time, right?
Yeah.
If you do some pre-litigation and then you don't settle, and then there's discovery, and then a lot comes out. So I think material new information really does justify a new valuation and a new strategy. Okay, one more question.
Okay.
This one from Danny. How should plaintiffs' counsel recalibrate negotiation strategy in a near final employment settlement when defense delay appears driven by client indecision and insurance uncertainty, particularly where the plaintiff has already made significant concessions and risks signaling further flexibility? Okay. So do you want, I
Yeah,
think
you and so what are you asking what to do in this scenario? What is
I
he?
think I think I think they're asking what to do. So maybe I'll take a pass at this. Okay,
Yeah.
so I think if the question is, How do you continue the negotiation? I would probably not be so focused at that point on the numbers. And if the delay here is caused by client indecision and insurance uncertainty, then I would be thinking about process steps. What needs to happen by when? So, Stacie, what you were saying earlier, time-bound things, so that there's that idea of time scarcity. I might be thinking about different ways to put some pressure on the decision making, or at least find out, how do we get the other side into a position to actually make a decision rather than trying to negotiate and change the numbers. Because that, at least my read of that question, um, the delay isn't about the number, but about the process. So I would look first to see what is causing the delay. And if it is process, then I deal with process.
All right. I, I kind of feel like it's always the case that the insurance had, or at least they're telling me, I don't have authority for this, or I don't know, I want to get more authority for this. And the client's saying, I can't just, so this is too much. And I've already evaluated the case this way. And now, Stacie, you're asking me to give more. That is a lot of it. Proposals give time on that for them to think about it. So that would be something that would come
Mhm.
into my mind. Are you not able to move anymore? Is that the problem? What can I ask the other side for that's going to help you here? Is there a document? Is there specific information that would change your indecision? So I'd
Mhm.
be working with the indecisive party on how can I help you settle? What do you need from the other side here? Why
Mhm.
are you stuck on this? Why are you evaluating the case this way? So sometimes we could go to mediator's proposal. I think a lot of the time they don't want to give more, they're indecisive about giving more, and sometimes it's the carrier and sometimes it's the client. It just depends on the mediation. So I would definitely work with them. I mean, information is very important. So information management is important to all of this. When we give information, how we use information. Documents are any written evidence. Gets rid of the he said, which is very common in employment
Mhm.
mediations. The chef told me, grabbed me or said this awful sexual thing to me. Chef says, no, I did not. Defense says there's no one who heard it, so it didn't happen. Well, it's possible he said it to her with no one else around, right? And so we are often he said, she said, not always.
Mhm.
And looking for witness statements can be helpful. Complaints in writing are helpful. That doesn't mean a verbal complaint doesn't count, but it's just so much more persuasive. So, working with, if we have anything written, lawyers, that specificity and written documents help us so much. So, I made a complaint. Well, when? To whom? How? You know, all of that, those specifics are making your message so much stronger in both rooms. And what do you have to support it? So you did an investigation. The other day they said they did an investigation that HR did, but there's not one note or investigation report. Not one. So they can testify they asked people what happened, but if you have the document, that's going to be a lot more persuasive for me in showing plaintiff an investigation was done. So some of the indecisiveness has to do with information. So I would say get us your best information. And we'll work with the indecisiveness and the timing and whatnot. It's one of the things we typically see in all of
Mhm.
this. Our job's to persuade everybody to get to similar settlement evaluations. They don't need to be exact, but if everybody could kind of look at this in the same frame, we're going to be able to get it settled for you. So we need to use information to do that. And that's why if we're so insulting, they don't want to give us information, or they'll give it to us but don't want us to share it. So
Mhm.
we are working on process like MyKhanh is saying and trying to get you what you need. That was a very long-winded answer, I think, to the
No,
question, but I think it's a really good, both the questions were really good. Um, okay, a few tips, and then we're going to get back to MyKhanh. Um, One negotiating tip I want to give you is stop short of where you're really willing to go. It makes it 100 times easier for me to settle your case. People want to feel, when you do this every day, you see people want to feel like they're getting every last penny or they're getting the best deal possible. So if there's that stretch, so if let's say you have 200,000 and you stop at 100 or 150, that's going to feel a lot better to a plaintiff. And plaintiffs, if you say, I want 600 and then you take 300 or 400, that's going to feel a lot better to defendants. So stopping short of where you want to go is a very good technique at optimizing your settlement outcome for your client. And I literally see this every single day, the impact of it. And the other day they stopped and she's like, I can't give a penny more, Stacie. Well, and then she said, I should have stopped early. She even said it herself. I should have stopped earlier because now they'd feel good. And they kept coming back expecting her to give a little more and she couldn't give another penny. She was like, I literally can't do it. MyKhanh, are you seeing this as well?
Yes. The no, I promise you this is it. And I was like, don't actually. Like the last best and final that you know is not the last best and final, so I try to not let people say last best and final on things because they've left them some stretch a
There's
lot of time.
usually. And that whole last best final thing is tricky. So some people
Mhm.
use that as just like colloquially to say, I'm stopping here.
Mhm.
Others say, I don't want to say last, best, and final because then it's a lie and it's not my last, it's my stop. I need some language to signify a stop because where us mediators can do, and especially in employment where there's very infrequent overlap, we
Mhm.
usually have a gap. That's the gap is where we do our magic. I mean, we're keeping you moving and trying to make it productive the whole time, but that gap is where we got our hardest work. So I would say, I think in my mind at least, I need like an hour with the gap. If you are trying to settle, if you have 4 hours, I got another one after, and you're not hitting your stop until 5 minutes before, that makes it very difficult. So leave your mediator some time with your stop. You could call it last, best, and final. If you feel like that's not honest, you could call it my stop. Or you just need some signal you're not moving again in this negotiation dance. Like that's what you got authority for. That's where you're settling it for. Some language so that I can mind the gap. I can breathe.
I'm asking people at the beginning of the day for their end of day numbers.
You are?
Yes.
And are they giving that to you?
Well, just to indicate in that conversation that that is where the real work is going to be. So if we're spending too much of our time on the edges and running out of time to really work on that last stretch where we need to close, then everyone's tired at the, real end of the day, and then it gets harder and harder. So if we can do away with, the incremental things that take a long time and frustrate people and really kind of irritate people, then I say, let's spare ourselves so many of those moves, get to the end of day numbers and leave ourselves time to, really work on that. So yeah, it's a
Okay,
version.
interesting. So this is the great thing. So mediators can do things very differently. We all do. And we can get to the same result at the end. There's not like one style of mediation. I don't do that. In fact, one of my things was don't give your mediator your bottom line because then they hear it.
Oh,
So,
I'm not asking, they're not giving me their bottom line either. I'm
oh,
not
they're
actually
not.
asking for bottom line, or nor do I expect them to be giving it to me. That was your mentorship to me. That, don't ask for the last
You
stretch.
just want the range of where
I'm just
you're
wanting the
going.
range. Yes.
And that's interesting. So I'm curious for you lawyers, how many of you actually give that? Some come in and they're like, Stacie, well, this is fun. Some will come in and say, Stacie, this is mid five figure. I'm not going to six figures. And then at 3 o'clock, they're in the six figures heftily.
Mhm.
Now, this is the problem for us mediators is so many people say are positioning certain things, not being totally truthful. I'm fine with that.
Mhm.
It's not a bad negotiating strategy, but then I expect it, you know. When I
Mhm.
train mediators a lot, I'm always say to them, you know, your job's to not just believe every single thing, keep working, you know.
Mhm.
So it's interesting. It is, some people give it to me early, the range. Others are like, I'm not going there until we're at our stop and I need it, or I need it for the hypothetical offers or media
Yeah.
proposals. So it's very interesting. I love, like, even if Mikan and I do it a little differently, because there's so many ways we can do it, which is
Mhm.
great. And you find the mediator you connect with, whose style you like, and it's all good. So I love that. Okay, let's talk about. Okay, there is a social science concept. I think it's a cognitive bias also, risk and loss aversion. So people would prefer to take a sure thing over a risk. Fantastic, right? Settlement is a sure thing. Why are we going to risk it? Us mediators, you've heard your mediators probably in every single mediation talk about the risk of trial because it's strangers and we don't know what's going to happen, right? This is why 95% of cases settle. You losing control for strangers, and everybody sees things differently, even within our own house. I always say with my husband, something will happen. I'm like, oh my gosh, I'm outraged. My husband's like, that is so not a big deal. And so what we could be on a jury and find totally different. And we picked each other. So I think there's always a lot of risk. Trial risky, settlement certain, fantastic. Now here, and people have different risk propensities. I'm a chicken. I do not even like to gamble. I have no risk tolerance whatsoever. Other people are like, yeah, bring it. I'm going to trial. You know, it's just very different. Here's the problem. Loss aversion is 4 times stronger than risk aversion. And that means people will rather take a risk than a sure loss. Now, this is the harder sell because defendants are for sure paying money. That's a sure loss. And they rather take the risk at trial. So mediators were trying to frame the entire time as what is the gain? What is the benefit to you to have this deal? Because we know at the end of the day, you are going to have to go tell your colleague or your boss or your client or your spouse, whoever it may be, why this deal is a good deal, why it makes sense. Knowing this, we should be working towards that in a mediation. So instead of saying, I'm going to be a gladiator and pound the other side, it is helpful to give us information. We've got a lot of it because MyKhanh and I are doing it every day. Why it is a benefit for a defendant to pay you this money in defense. What are the benefits of plaintiff being out of this case? You know, money in their pocket now is an obvious one, and the emotional benefit. And obviously, for defense, you know, you don't want all this business disruption. But help us sell it. Help us. And that's where information management helps. We're new to this dispute. We're coming in. We've gotten briefs we've read a couple times. I know MyKhanh does that, and MyKhanh and I do pre-mediation calls. So we've had conversations, and now we're learning from you guys in the mediation. So you're going to be in a better position than us with the specificity of the risk and the loss in all of this. So keep that in mind. You want to sell the benefits of the deal to the other side. Creative resolutions are possible in the employment context. Before I started working with ADR services, it was 10 years ago, I did do panel mediations for the DFEH at the time. And we always had to have a creative component. So that looked like training or posters or it could be anything. So keep that in mind if that creates any value. Sometimes somebody wants the bad actor fired, especially if they're still employed, which is kind of rare. You could do neutral references are pretty common, but sometimes a positive reference can be something. Once in a blue moon reemployment or employment at a different office, if the HR thinks there was a bad actor who was terminated, they don't have a problem, especially if you're pre-lit, reemploying. So keep this in mind. Creative resolutions are fantastic for bridging the gap. Wage allocation can be helpful too. The lower the W-2 payment, typically the easier sell it is for us because they're getting money in their pocket. And defense, we can indemnify typically for any tax consequence related to their tax characterization of the settlement of payment. So we can try to protect you should you do that. So keep that type of thing in mind as well. For those of you who don't have insurance, when your clients don't have insurance, payment plans can sometimes work. Plaintiff counsel, if you have a payment plan, you typically want a stipulated judgment to protect your client. And defense, you want to have some cure period to protect your client should they miss. Auto pay's been great in this scenario because some defendants don't want to miss and they don't want to think about it. And therefore, auto pay just kind of is like, I don't have to think about this again. So these are options we can have. Backward step, I was going to say, don't take them. So that question's great. That it ends your mediation. A backward step's going to end the mediation, but maybe that's the appropriate thing, and we can talk next steps there. With that, never make a concession without getting one in return. Sometimes they don't like it, and they're like, "Give me another one." No, I'm not giving another one until you make a move. That it would be good negotiating behavior. Don't do that. Bottom line arranges. I love MyKhanh does that. If they're going to give it to her, it is going to make it a lot shorter of a dance, right? If you guys want to give those types of ranges. There's a whole movement, and MyKhanh knows this because we're in this International Academy of Mediators together, where it's 3 moves only in the mediation. A lot of people are not comfortable with that, but that would foster the type of thing MyKhanh's talking about, which is, why insult each other? Why not just get to it and see if we can resolve it for you? So MyKhanh's kind of incorporating some of that as well, which is great. Okay. And let me turn it over now to what happens at the end of the mediation when you settle or you don't settle. So MyKhanh, take it away.
Okay, all right. So I'm gonna keep going even though we're at the top of the hour. For those who are staying on, I think they're gonna adjust the MCLE documents so that you have more time, certification, so that you get more time. I think that's what happens next. But understand if you all need to drop off, but we're gonna stay on to finish off and talk about what happens at the end of the day and some of the considerations that we recommend. All right. So if your case does not settle, first of all, let's talk about the sometimes rare occasion that your case does not settle on the day of mediation. That doesn't mean the mediation failed. You still likely gained a lot of important information. You probably have a much sharper risk assessment and a clearer understanding of how the other side will present their case. And really importantly, a better sense of where their real numbers are. That's all valuable information, and that's helpful for the next move. So when the question becomes how do you, so then the question becomes how do you preserve and build on that momentum? Hey, both Stacie and I highly recommend that you have a follow-up plan before you leave. Don't leave the mediation open-ended, right? Be specific. Do you want your mediator to follow up in a week? Do you want your mediator to follow up after a particular deposition is taken or a motion is decided or before a complaint or arbitration demand is filed? Give the next conversation a time and a trigger to follow up because follow-ups work. Follow-ups work really well. People think about risk differently after reflection, and clients process differently overnight. New information may land differently outside the room. So even if your mediation doesn't end in a settlement at the end of the session, Stacie and I often say it just means it hasn't settled yet. So when you have a follow-up plan, it will very likely result in a follow-up. Okay? So remember to set the time and trigger for your mediator to follow up. If your mediator doesn't ask, if your mediator doesn't offer one, just ask for a follow-up plan. Right. So the more common outcome is that you do settle the day of mediation. And if you reach a deal, lock it in. If you're in person, the expectation is usually that your client signs something before you leave. And that eliminates the risk of settler's remorse or any outside influence or second guessing overnight. Zoom mediations have changed that dynamic a bit, and the long form agreement very often comes later. The attorneys will decide that they're going to email like the next day or the following week. And if that's the plan, then we recommend that at a minimum, you confirm the material terms in writing before you break for the day. Set out the settlement amount clearly, and any other key terms like payment timing, the scope of the release, anything that could become a friction point later. Some of those things that Stacie talked about earlier, the tax allocation, the neutral reference, those are the types of things that if they're material, you should put into your confirmation email. Okay, and a bit of really great advice that Stacie, I heard from you at the last time we got to present together, is that if you rely on any information in mediation that's critical, for instance, whether insurance coverage is available or not, or the financial viability of the defendant, if you've discounted the settlement because, it's going to be pennies on the dollar because of a solvency issue, you might want to include that in the recitals. Because if you find out later that the information you relied on is wrong, the mediation privilege would protect the confidentiality of the conversations in mediation, but the recitals in the agreement can be considered for the purpose of enforcing the agreement. Stacie, you should actually speak to this because you're the one who gave me the advice, and I'm giving you like
I like it. You
I'm
did it.
talking back to you the advice you gave me. But I think that's really, really great advice. Put it in the recitals.
Yes.
Okay, so when
You,
I mediate, I'll draft the confirming email with counsel before it goes out. And so in each room, walking them through what the email says so that when I send it, then they can hit reply confirming, they can reply confirming the agreement. And I think that at least gives you a better assurance that the deal will be consummated. So, because at the end of the day, the goal is a durable agreement that everyone can stand behind. All right. Do we have any other questions in the chat? Okay, if not, maybe I did not need to give that big announcement that there was going to be extra time because I think
we're
we kept
bringing
it
it in
tight.
on time.
Yeah, I think we did. All right. Well, we hope you gained tools you can use in your next mediation to move the numbers and manage the dance and protect the outcome. If you have any questions or want to discuss any of this further with us, please reach out. We're both with ADR Services, and you could get our contact information somewhere or maybe on LinkedIn. And we want to thank you for spending the time with us. Have a great night. Thank you.
Thank
Thank you,
you,
Stacie.
everyone.
Thank you,
Glad to have you
everyone.
here.